Well, welcome to the periodic webcast for the Syracuse Intellectual Property Law Institute and Technology Commercialization Law Program at Syracuse University College of Law. This is Professor Shubha Ghosh, usually moderates these webcasts, and I'm pleased to have with us Professor Ryan Calo, who is the professor of law at the University of Washington School of Law and the co-director of the Technology Policy Lab at the University of Washington, which brings together scholars from law, policy, and computer science. So welcome, Ryan. He'll be speaking about his paper with Danielle Citrone on AI and the administrative state that's forthcoming in the Emory Law Journal and is available on SSRN. I'll have a link to the paper in the description below. So thank you. Thank you again, Ryan, for taking the time.
Oh, thank you so much for inviting me, and I'm excited to talk about my work. I wish I could be there in person as we'd planned, but one day soon.
Yes, one day. Yeah, we're sharing this with the Autonomous System Policy Institute and also the College of Law, and we've been planning to have Ryan come out to speak to us here, but well, various viruses got in the way, I think, during the course. But welcome, thanks for doing this, and we look forward to a live meeting in the fall.
Sure.
So tell me a little bit about the paper. Tell us a little bit about the paper, the main thesis, and I think the very interesting policy prescriptions you have at the end.
Sure. So, over a decade ago now, Danielle Citrone wrote this paper that is called Technological Due Process, and in that paper, she made a case for the ways in which the use of automation and algorithms and what we've come to talk about as artificial intelligence by administrative agencies at the federal and state level was interfering with due process and interfering with the safeguards imposed by the Administrative Procedure Act, or APA, around notice and comment rulemaking. And this paper, Technological Due Process, was very influential. And in the decade or so since the paper came out, a number of scholars have said really important and interesting things about what effect it has when agencies turn to algorithms and automation and the like in order to make critical decisions about people that are regulated entities or people that are getting some kind of service or benefit from the government. And the other thing that happened in the last 10 or so years, especially in the last few years, has been that there have been these legal challenges to the very kinds of programs that Danielle identified in technological due process, where lawyers on behalf of the disabled, on behalf of teachers, on behalf of unemployed workers of various kinds, have brought lawsuits against states, usually states, for reasons we can get into, state agencies, but not exclusively, challenging their decisions that they've made by algorithm. And so Danielle and I have known each other for a long time, and we're both in the privacy and internet law space. And we decided that we would look at this litigation and look at this literature again 10 years or so, 12 years after Danielle's original germinal piece. And what we found was that not only were things just as bad as they were, years ago, but that the trend had only accelerated. Mm-hmm. And what was really clear from the litigation in particular was that the agencies that were using these tools, these algorithms and this software, they didn't fundamentally understand how the software worked. They couldn't detect errors. They couldn't fix errors. When they were put on the stand, they couldn't respond to basic questions about how this stuff worked. What they struck us as was inexpert and paralyzed by by the fact that they had gone ahead and automated something over which they used to exercise discretion.
Yeah.
And so one of the opening examples that we use in the paper, which is really quite vivid we use it by design, is there was this program that where a state had sought to replace nurses who were going to people's homes to figure out how much in-home care they needed. These were disabled individuals, people living with disability, and they were given a certain amount of in-home care hours. And what the state would used to do is they used to send a nurse there, and he or she would do a questionnaire and look at the person and talk to them and see what their needs were and then make a recommendation. Well, they thought they could save money and maybe even be less, subjective by automating this process. But they did so in a way that was just bizarre and cruel in its impact. And as one example, we talk about, this came out of litigation, there was the system understood that a person would need less care for foot issues because their leg had been amputated. And this is the kind of perverse mistake that only a machine could make. You know what I mean?
Yeah,
and so,
yes, exactly.
What we decided to do was, rather than rewrite Danielle's paper or the many other interesting papers that have come out, Joshua Kroll et al.'s paper in Penn, Kate Crawford and Jason Schultz's paper about due process and privacy in the algorithmic state, and many others. Rather than try to rewrite those papers, we decided to look at it from a different perspective. And what we decided was, look, at some point, if this trend towards automation continues, and if it remains as clear as it is that the administrative officials who are turning to software and automation don't understand what they're turning to and are rendered inflexible by it, not only does that interfere with due process, but it begins to undermine the functionalist case for why we have administrative agencies in the first place. And so we decided to go back to administrative law principles. I teach administrative law at UW. To first principles about administrative law, first principles about delegation, and to just begin to ask the question of, well, gosh, I mean, the functionalist account of why Congress, which after all has been committed legislative authority by the Constitution in a pretty clear way, right? And why is Congress able to create these other entities that are not Congress in order to, govern? And the classic answer to that question, because there's been a lot of pushback that remains today as to why this is constitutionally permissible. The classic answer has always been, look, the world is complicated and these agencies accrue deep expertise and they have the flexibility to respond to dynamic conditions on the ground and to individuate their responses in a way that Congress can't do. And so Danielle and I think it's fair to ask at some point, if these same agency officials are throwing away expertise, throwing away flexibility and discretion with both hands by turning to automation, at what point does that begin to undermine the very justification for the administrative state in the first place? And so, we are celebrating the litigation and the information we've garnered. We're celebrating the efforts of places like AI Now in New York that has assembled those litigants to talk to one another and captured the knowledge that they've created. And we're celebrating the many great works that preceded Danielle's work, like stuff by Paul Schwartz at Berkeley, which came before Danielle, and then all the stuff that's come since by all the scholars I've mentioned and many others. And then saying, but in addition to that, we also want to say that at some point, it's not just about the fact that due process is interrupted, not just about the fact that you can't do what the APA asks around notice and comment, that maybe we're making kind of a rulemaking, a kind of a regulation by robot, which two authors, Carrie Coglianesi and a co-author write about this. It's not just that; it's also like, let's re-examine why we have these things in the first place. Because after all, if it's just a matter of turning it over to software then
Right.
Congress could do that. Like Congress could hire developers
Yeah.
and enact their will directly. Anyway,
Yeah.
so that's the basic premise, and then we draw some distinctions about how we think that we don't think the answer is to dismantle the administrative state,
Right.
and we have some principles for how the administrative state can interact with technology, and that's the paper in a nutshell. And we're really excited for people's thoughts.
Yeah, no, thank you so much. And I thought it was a fantastic paper. It's highly recommended. I look forward to coming out and see the reaction and the follow up. And I really like the way you get into the political science and the theory at the end, the administrative law theory, and really try to walk that line between being a Luddite, if you will, and also being anti-administrative state, which is kind of the problem here, is that there are people who do want to dismantle the administrative state and might view AI as an opportunity to do that. I mean, it's kind of the tragedy. But sorry, go ahead.
Absolutely, yeah, absolutely. I mean, I just want to pick up on that point briefly. I mean, the reason that some of these agencies are turning to automation is because they face a political economy that has been so skeptical of agency power and has been chipping away at the administrative state, both directly by limiting it through reform, but also just by not giving the agencies the resources that are needed. I mean, if you look at the Federal Trade Commission is not turning to automation much that I'm aware of, but if you look at the Federal Trade Commission, this is supposed to be the watchdog for like the entire country in every sector except for common carriers and financial companies.
Yeah.
And it has a lot of people, but nothing like the number of people that would be needed to do that kind of job. And so they have to be highly, highly selective in the kind of enforcement that they do. And the area that I know best is privacy. So the administrative state has been faced a concerted effort for decades to kind of really limit them. And I don't think the answer is that we don't want any regulation, or we don't want the administrative state to let regulation, but rather, nor do we want to deprive agencies of these powerful tools that they could be using to make wiser decisions and to realize some of the efficiencies that the private sector has realized. We just don't think that they should be automating their tasks using systems that they don't understand, which is a different claim.
How does this really, one of the things that struck me just from administrative law theory and practice perspective, and then we can go to some examples very briefly, because I know your time is precious here. One of the things that struck me in the background while reading your paper is how it kind of parallels debates about cost-benefit analysis. And I don't know if any administrators ever put on the stand as to whether they really understood cost-benefit analysis, but that seems to be another sort of pre-AI kind of trying to look at sort of mechanistic rules rather than thinking about to use the buzzword, the affordances of the technology. So is there a parallel there with the cost-benefit debate, or
that's a great question.
use of the methodology? I realize there's a different, there are differences, but just in terms of the methodological debate and the.
Absolutely. I mean, so Danielle and I realized that there were going to be some analogies, right? And I think that's absolutely, with all law and technology scholarship, I think a very fair question to ask is this really so different, right? I mean, aren't phenomenon like this happening in other ways? And often the answer is that they are. So from the paper, I'll give you an example from the paper, is we thought about, and I ended up doing a bunch of research on, what about when agencies outsource their tasks to private vendors? Do you know what I mean? In general, humans.
Yes, right.
So,
yes.
And so maybe these are private contract military, or they're just people that
prisons,
are,
prisons, things like that. Yeah.
Prisons and so on. Doesn't that do essentially the same thing? And in fact, sure enough, when we looked at that literature, there were parallels there. I think it was a little different because it's less inscrutable. It's more,
and I think that the politics is a lot different too. I mean, it's more, I hate to use blatant or obvious what's going on with the privatization of these government services. I think the AI aspect, as well as the cost benefit analysis, is this kind of well, let's try to get rid of discretion and try to make
Yeah.
rules, and part of that rules is to maybe limit the number of actual people you have to pay in an agency to be
Yeah.
crude
I
about
mean,
it. Or yeah, go ahead.
the other thing that is not really in the paper, but I'm just thinking about now is, I mean, obviously there are times when Congress chooses to limit agency discretion by imposing upon them some kind of very specific cost benefit analysis,
Right.
even to the point of imposing upon them an algorithm. So if you
Yeah.
think about, if you can think about sentencing guidelines as a kind of algorithm, right? You know, I think the word algorithm gets tossed around a lot, and it always sounds like it's some kind of AI or some kind of inscrutable machine. But an algorithm is just a recipe,
Right.
and
Right.
there's some
Right.
pretty complex recipes that Congress. But then there is a legitimate function there, which is that Congress is saying in that instance, what we want you to do is follow these very precise guidelines. You know what I
Yeah.
mean?
Right. Right.
So,
Exactly.
sometimes agencies will use cost benefit analysis in order to reassure certain political constituencies and industry that they won't just be regulating to regulate. And so
Right. Right.
famously in my world, that was the case in 1980 when the Federal Trade Commission expressly adopted cost benefit analysis under the unfairness doctrine,
Mm-hmm. Mm-hmm.
because it was getting pressure from Congress at the time. They were
Yeah.
saying, you're being too moralistic about this. You're saying
Right.
anything is unfair, but so what's the structure there? But I
Right.
would
Right.
say, for me, I feel like cost benefit analysis is the kind of thing an agency could have expertise in, and in theory could explain why it's doing it. And it's still, there's still the kind of drive towards efficiency, which is what's a catalyst here. But I don't
Right.
think cost benefit analysis as a process as being quite as inscrutable and devoid of
Right.
expertise,
Right.
and you know what I mean,
I understand. Yeah. I mean, it's like the spreadsheet. I mean, it's like talking to somebody, the magic of the spreadsheet. The spreadsheet tells us the budgets don't balance, and so we need to do X, Y, and Z. But it's sort of ignoring the complicated decisions that have to be made that are not just simply that can be reduced to a spreadsheet. I give the
sure.
spreadsheet example because I've run across that in many bureaucracies, both at the
Yeah,
university and outside. So,
the tyranny of the spreadsheet is real. Yes, I agree with you. Yeah,
there's
and,
another.
and, and
Sorry.
analogous.
Yeah, sorry. Another side about this too that struck me about reading the paper is this whole notion of black box, the AI being the black box. And of course, when you're thinking about the discretion of a administrator or the discretion of a judge, there is a black box quality to that. I mean, we try to humanize it by saying what's what the judge had for breakfast, that realist
Hmm.
mantra. And I guess there's a sense that we can relate human to human, and we know kind of how if you can sort of put yourself in the shoes of a judge and a administrator and say, well, if I were deciding that, this is what I would do. But there's still kind of a black box quality, especially when we think about deference rules in administrative law. We just sort of say, well, they decide and they have their way of deciding it. But how does that play into this? I know it's different. Is it just simply that we can understand at some level the psychology of a administrator or a judge because we're all have a common human culture or some human understanding of psychology, while the AI is just plainly inscrutable still? Is that sort of a good way to think about the difference? Or is there just no difference? Am I just making a false analogy here?
No, I mean, I think it's a very fair question. I mean, so a couple different things. In a great thing, I think, about our system, our legal system, especially a common law system, is that judges not only have to decide these cases, and we have a problem of other minds always, but yes, we can
Hmm.
sort of put ourselves in their mindset, but they also have to explain their reasons.
Right.
You know what I mean? I mean, and so
Yeah.
even though like maybe the Supreme Court is just the last word on something, but at least the justices have to say why they did something. And when they say why in a way that doesn't make any sense, then the public and scholars and dissenters are able to critique that. And people like James Boyd White,
Mm.
who I studied with
Yeah,
at
yeah,
Michigan,
yeah.
talk a lot about how justice is a form of translation, and that
Mm.
reason giving is an important component, right?
Yeah,
And so that necessity of reason giving is baked into the administrative state by the APA. I
yeah,
mean, the
yeah.
APA, even in formal rulemaking, which is pretty lightweight stuff, you gotta have a statement of reasons, and the DC Circuit in particular has given teeth to that and said you can't just say we did it. You know what I mean?
Right, right.
And so that ability to interrogate a person and to hear their reasoning, I think that's a difference that matters,
Yeah,
and it matters
yeah,
both in
yeah.
administrative law and it matters in common law. Whereas with machines, it's just sort of like the spreadsheet told me to do it,
Right,
or this
right,
is
right.
what the formula came out.
Yeah,
And
yeah,
I can at most talk you through like the procurement decision I made for why I bought this software, but I can't tell you how the software works.
yeah.
And
Right.
when you put me up on a stand and ask me to give reasons like like our legal system expects, and
Right.
I find I can't because I don't understand the system, that strikes me as a distinction that really matters.
Yes, yes. Correct. It's like giving up judgment. I mean, the whole point of being a judge is to have judgment. The whole point about being an administrator, part of it is to have this judgment, and you're just
Yeah,
forfeiting that. I mean, you're giving that
but
up.
I do want to acknowledge that I think that a deep skeptic, like our sort of caricature of the legal realist, who believes in the essential indeterminacy thesis with his or her whole being. You know what I mean?
Hmm.
Like someone who's like
Yes.
a sort of a radical legal realist might say, well, look, at the end of the day, this reason giving stuff is a bunch of BS.
Right. Right.
What happens is that there's some gut impression, and then we try to backfill that with
Yeah.
rational
Yeah.
you know what I mean?
Right. Right. Right.
And so I get that, and I suppose if you're that deeply skeptical, then some of these distinctions vanish. But I personally am more on the legal process side of things.
Yeah.
I'm
Yeah.
not quite so skeptical.
Yeah.
Mhm.
And I've been reading or rereading Hannah Arendt and thinking about her views on judgment and what it just means to live as a political being, and that the kind of notion of bowing to the spreadsheet is it's not consistent with that. Let me just leave it at that. But so it's really interesting to see how this debate is playing out that way. Let's move to some examples about maybe 10 minutes or so. Again, I know your time is precious and I appreciate it.
No, I appreciate it.
Um, one of the things you mentioned was state. There might be a difference between state and federal. I think you mentioned that with your Arkansas examples and some of your other findings. What is that difference? I mean, one of the things that struck me when you mentioned that was the launch of the Affordable Care Act. Is that somehow related to this deference to AI or to technology, or is it just a typical, not typical in the sense of we expect it to happen, but just error. It just happened, but it was not this. It was a difference in kind from the kind of examples you're talking about in the paper at the state level.
Well, so it's how in our in our world, as legal academics and as lawyers, we're taught to sympathetically engage with counter argument. You know
Right.
what I mean? And so one of the limitations that Danielle and I are candid about in the paper is that a lot of our examples involve states, not
Right.
the federal government.
Yeah.
And but we do also note that there are enormous forces in the federal government that are pushing towards greater automation,
Hmm.
right? I mean, there's Trump administration executive orders, but there's also all kinds of internal documentation, all kinds of requests for proposal. I mean, it looks like there is a massive shift underfoot to how federal agencies can use artificial intelligence and automation. And they already do in some contexts, like the no-fly list
Right.
or maybe
Hmm.
affordable healthcare, which we didn't get into. But the examples that we have from litigation tend to be state-based.
Right.
Why is that? Well, that's complicated. I mean, you know, I don't want to try to even venture to do like a little, discussion on this, but the truth is that it is not easy to sue the federal
Right.
agencies. you know, you have all these
Right. Okay.
requirements that are part of. I mean, again, I mean, this, I don't want to get too in the weeds here, but just to back up a little bit and just say, you know, the federal government as well as the individual states have sovereign immunity,
Right.
and so that means they can only be sued when they let you sue them.
Right.
And the truth is that the APA does allow you to bring a lawsuit against the federal government under some very narrow
Right.
conditions for defects in administrative process, but you have to go through a lot of hoops and so on.
Right.
So
Right. Okay.
maybe that's the impediment. Issues about, but maybe it's just more that the people that are suffering by these automated decision making systems happen to be at the state level. And so we are speculating a little bit, Danielle and I, that this is going to become a widespread federal phenomenon.
Yeah.
You know, that said, a lot of agencies just kind of, you know, a lot of state agencies, they experiment in a way that the federal agencies then pick up, or conversely, they follow the lead of the federal agencies. There are many APAs in almost every single state that are functionally very, very similar to the APA. And so this dynamic probably will play out similarly in the federal. And then research out of Stanford, that I don't know whether it's come out yet, but there's like a team of students and some faculty at Stanford Law School that are canvassing automation and artificial intelligence use by federal agencies.
Yeah, I've seen
and they're finding it to be absolutely widespread.
Right.
Absolutely widespread.
Yeah. So to foreshadow a bit, when you do visit us here, Ryan, at Syracuse, we do a lot of we have a veterans clinic, and so that might be one agency to think about as to how that's happening. I don't know offhand, but I'll definitely talk to my colleagues there, and they'll probably visit your talk when you visit. So
I'd love that. I'd love that.
A set of examples.
But
sorry, go ahead.
I was just going to say, the examples that we use in the paper are things like determining compensation of teachers, determining in-home care for people living with disability. We do use the no-fly list because there has been some litigation and some light shed on that, although not enough. We use benefits in Michigan. We used a lot of different examples.
No, they're great examples. They're great examples. I recommend the paper. Let's talk about some other examples, which follow up from your and Professor Citron's sort of prescription. I think you end with this interesting political science model of thinking about AI as branching, and you can explain that a little bit now if you'd like. But as I understand it, it's really tapping into the expertise of the agency, using the technology to sort of complement that and to enhance it, rather than to substitute for it. I know I'm simplifying. I'm sorry, but I think that's the main message. So go ahead. No, go ahead. I'm sorry if you want to correct that or build on that.
No, I don't want to correct it. I mean, I think that's right. I mean, ultimately the prescription that we come to, which I think is fair to say is the least developed part of the paper, and this paper is not in print. It's forthcoming, and we're still taking we're happily taking feedback. But what we end up saying is that there are uses of artificial intelligence, which, but by the way, just to step back, when I say artificial intelligence, I think of artificial intelligence as like a set of techniques that such as machine learning that aim to approximate some aspect of animal or human cognition.
Yes,
I mean, we're talking about a broad swath of things. But what we say is there are uses of artificial intelligence that tend to reinforce our confidence in agencies and their expertise, tend to augment, as you put it, the agency's expertise and flexibility, and maybe permit agencies to do some of the things that the public expects them to do, but in fact, they're not well positioned to. And so what we do is we draw a distinction between muddling through and modeling through. And the muddling through comes through political science, through Lindblom's extremely influential paper, The Science of Muddling Through, which I was shocked at how influential that paper was. I knew the paper, but when I read it and I saw how often it's cited to, it is enormously influential.
Mm-hmm.
And the thesis of that paper is that regulators ultimately are not able to make a first best world decision. They just don't have the ability to look at the world and say, what's going to maximize for everything? How do we gain the goals that we wish while still maintaining the values that there's information gaps, there's resource gaps.
Right.
It's just
Mm-hmm.
very, very difficult. And so what they do instead is they can't do what's called the root method. Instead, they have to do the branch method. And so what they end up doing is they just kind of tinker something over here, something having to do with financial markets or something having to do with health or pollution. They tinker over here a little bit to accomplish one goal, and then they see how it plays out. And then if they overcompensate or undercompensate, they do something else. Or if it causes another problem, they address that problem. It's this hydraulic, constantly moving, dynamic picture where they incrementally over time get to the best place they can, but they can never use the root method, which is let's figure this space out and so
Oops. Okay.
And so what we end up saying is that there will be ways in which artificial intelligence will give, again, while preserving agency expertise, help agencies model the world better and thereby make wiser decisions, is the hope.
Interesting. Yeah.
Which is not the same thing as like automating everything. It's more like trying to get a better sense. And you're kind of seeing that now with our response to the coronavirus.
Okay.
I'm testifying this week before the U.S. Senate, before Commerce, about the use of data in combating coronavirus. And there are some really interesting positive use cases, both in terms of understanding the disease and its structure and how to and what will work to make better outcomes for patients, but also to figure out things like, are people social distancing enough, and what is the effect of social distancing and the like. And then there are other irresponsible uses of data that seem not to obey any kind of rough cost benefit analysis, but just there's kind of people just getting enamored of the gee whiz bang. Hey, we could make an app for that. And so it plays out in real ways, in ways that matter to people. And I think that governments are making a lot of the decisions they are now when they are paying attention to statistical models that are developed by epidemiologists and supplemented by things like machine learning where appropriate. It really matters, and so that's the kind of thing we're talking about, although we didn't have the benefit of this pandemic to use our example.
I think one of the things I probably should have done at the beginning, so I kind of apologize to viewers for this, is really unpack what we mean by artificial intelligence, because I actually kind of admonish other people for kind of using that without taking apart things like machine learning and other sort of techniques. I mean, sort of the data-driven predictive analytics, all of these types of things that really constitute AI. That's important to understand. And I think one example that you might want to comment on would be, I think in this current situation with the pandemic, I think Taiwan has been looked to as a model for the use of things like data analytics and machine learning to somehow, and I think their experience has not been as extreme as other countries in terms of the spread of the virus. Did you want to comment on that? It seemed like a very interesting example. I can put some links to articles below.
So first of all, I would love to see that, and especially in light of the testimony I mentioned. I mean, so there are a couple things. So first of all, I end up talking to subject matter experts here at the University of Washington. Here, in terms of where I work, I'm at my house, of course, but at University of Washington. But including epidemiologists, my colleague in biology, for example. And there's widespread consensus around the idea that if you can massively test people, for whether they have the virus, even if they're asymptomatic, whether they have antibodies that suggest that they're immune to the virus, that is incredibly helpful. So knowing that about people is incredibly helpful. It's also incredibly helpful for us to socially or isolate, to physically distance ourselves.
Yeah.
Right? Incredibly important tool to flatten the curve. I don't need to tell anyone that at this point. But beyond that, you would really need the kind of resources that the United States seems not to have decided to dedicate to this problem. What they're doing in Taiwan, what they're doing in South Korea, what they're doing in Germany. I mean, these are efforts that involve not just sharing information about who has COVID-19, right? But like verifying that that's true, testing people that wouldn't come forward ordinarily because they don't feel sick,
Yeah.
And then when they do come across as someone who they find to be COVID-19 positive, so therefore what's called contact tracing,
right?
Then they send out public health officials who are trained in this, and they come out there and they interview people, they find out who they've been in contact with, they force them to be in quarantine. I mean, these are dramatic measures, that you use to contain a pandemic. And the story of data and technology and all that, it's part of the story, but it's hardly the biggest part of the story. You know what I mean?
Yes,
like the biggest part of the biggest part of the story is that they like have an unbelievable number of test kits, that they've been deploying them everywhere, that they've been using the arm of the state to. I mean, the problem with one of the things that I'm going to get like a little bit worked up about this, but one of the things I found to be deeply problematic, and it really sets me at odds with a lot of people and institutions that I respect, I have to say, is the idea that we're going to write some app and that this app is going to be on all of our phones, and that somehow we're going to resolve the pandemic and resolve this Hobson's choice between social distancing and ruining our that somehow we're going to do that with being able to self-report that who has got the disease, and then using that to figure out where to avoid. I mean, it's just that is not a panacea that people think. Yeah.
No, and I was thinking of the Taiwan and South Korea and Germany examples as examples of how the technology is used moderately. Let me put it that way, with sort of the what you would expect the state to be doing in terms of trying to get this information and then trying to figure out exactly who has this and collect the kind of data we need to then, epidemiological data, the social data, whatever it might mean, to figure out treatment and containment and things like that.
And if we had done that, we'd be in a different spot, right?
Yeah.
If at the very beginning of the realization that there was this, person-to-person, easily transmissible disease that had a relatively high fatality rate, we had just said, okay, we are going to just, stop everything. We're going to put into place massive testing apparatus and so on. Then we'd be in a better spot. But it has nothing to do with like, whether we applied it. That said, like AI is going, like, people talk about how fast we're going to get a vaccine. People talk about how well we understand the structure of this particular novel coronavirus. Part of that is a story about having incredibly powerful tools.
Right.
You know what I mean? Like, I don't want to belittle that. Like, this is not,
of course,
this is not the flu of 1918, in part because we have so much, so many resources to draw from. We are globally interconnected. We have powerful machines to aid in our diagnostic. So it's like, don't let me belittle that for a moment.
No,
but nor is like technology or data a panacea here.
Right.
Yeah.
Yeah, no, I think we're on the same page. The technology is magic. I mean, we have the killer app, whatever it might be, without thinking about how it's embedded. I mean, it's the same thing with market solutions. Just have a free market, and without thinking about how it might be connected to other very, probably even more valuable institutions and values. You know, the thing that gets me, I want to not take up your time and turn this into like what gets each other, gets each other's
I'm happy
goat.
to hear it. Yeah,
But
yeah.
I was thinking about all this about tapping, you know, getting Google and the cell phone providers involved to tap all that data, and somehow the government will take it. What do you think about that? I mean, that obviously raises some privacy issues in order to, and I assume even the models you did with the state health officials going out and contacting people and quarantine them, you know, whatever it might be, raises some interesting privacy issues. But I realize I'm
Yeah,
conflating a couple of things in that question, but the whole thing about just simply getting all the Google data, the government getting all the Google data and cell phone data, and that'll also resolve it, also is sort of a, seems like a tech quick fix without really thinking about through how that data might be used and collected.
I think if we decided to flip a switch and become a absolutely totalitarian state, you know what I mean, where there were no limits and Google and Facebook could collect and give to the government anything they wanted, right?
Mm.
And then the government were willing to operationalize that knowledge in order to clamp down on the spread of COVID-19. Like if that's the world that we want to live in, which is dystopian, you know what I mean?
Yes,
That,
yes.
then yes, it would be extremely effective. Do you see what I mean? Like I don't think anybody, I think very few people in the United States would tolerate even temporarily that kind of suspension of civil liberties. That would be,
Mm-hmm, mm-hmm.
it would turn us into a state like China that was totalitarian, top down. You know what I mean? It just would be a
I
different kind of
understand. Yeah,
country.
yeah, yeah, yeah.
So you have that on one extreme. Sure, would that work? Yeah, probably would work. You know, on the other hand, even the data that Google is making available now, suggesting relative social distancing by jurisdiction based
Mm-hmm.
on aggregated mobile data. You know what I mean?
Yes.
Even that is useful
Yeah, yeah.
because what it tells us is who is respecting social distancing, and then it allows us to correlate the social distancing efforts with the breakout of the disease. Like, does
Right.
social distancing actually arrest, you know, growth of the disease? And so that's really helpful, right? So what I don't agree with is that somehow we're going to find something in the middle, which is like this sweet spot where we like almost totally address the problem while not brutally sacrificing civil liberties and investing
Yeah,
a
yeah,
massive amount of money in operationalizing an effort. You know what I mean? It's like, that's what I just don't see. You know what I
yeah.
mean? And so
Right, right.
I think that's important to distinction to bear in mind.
And this would be a completely different a discussion, or maybe a broader discussion as to how Taiwan, South Korea, and Germany and other jurisdictions get that balance between civil liberties and government intervention to deal with pandemics. I mean, that's kind of
If they
interesting.
do,
Yeah. Well,
and
okay. Well,
I'm not a comparative
right, right.
constitutionalist. I couldn't begin to
Yeah.
tell you,
I'm
but
not either, but
yeah,
yeah. So it's just interesting, though. It seems like, especially when you hear about things like the privacy directives in European Union and so forth, right? And why that, if that is what you describe is happening in Germany, that privacy has not been or if civil liberties more broadly has not come up, at least in the press. I follow a little bit about what's happening in Germany. I haven't seen it. There seems to be more of a compliance mentality there,
yeah. I
within
think there's a
limits, of course.
compliance mentality, and I'm sorry, I have to actually jump off
Yeah, no, I need to go.
but
Yeah,
yeah, and I'm sure you do too. But I will just say about Germany. My understanding about Germany is that they've done massive testing. That a lot of that has been actually private industry driven, you
yeah,
know,
yeah,
that, you know, and private healthcare driven, or public healthcare, but I mean, private industry driven. And that also there is a compliance mentality,
yeah.
but so they haven't been doing precisely what, say, South Korea has done, but they are contemplating all kinds of very invasive schemes to let people go back to work. And so
Right.
there is this talk about, you know, they like Italy are talking about, you know, giving you some certification that you are COVID, you know, negative,
Hmm.
and that you have the antibodies to it to allow you to go back to work. And, you know, especially in light of the history of that nation, that's something I'm sure is giving some people
Right.
pause there.
It
You know what I
must
mean?
be.
So
Yeah,
I don't think
yeah.
I don't think we've quite confronted the civil
Extremes.
liberties
Yeah,
extremes there yet.
yeah,
But I
yeah.
mean, anyway.
Well,
But
Ryan, thank you so much. I'm sorry if it's gone over a little bit than what we talked about, but I really
no, this has
appreciate
been
it.
great.
And
Yeah.
I'll distribute it, and a lot of great things for thought, food for thought. just at the outset, I'm sorry if I mispronounced your last name at the very beginning. I think I may have.
No, Calo is good. It's
Calo,
Calo.
Calo,
You said it right. Yeah.
oh, did I thought I said Calo, so I'm sorry about that. Anyway,
Either way,
we
Calo
have
it
it
is.
done.
Yeah.
So thank you again. And for viewers out there, there's more information below. If you like the video, please like it on the YouTube channel and think about subscribing. And thank you again. Looking forward to seeing you in Syracuse in a few months, hopefully.
Gosh, I hope so. Yeah.
Yeah. Thank you again.
Okay. Bye. Thank you.